Hey everyone, and welcome back to Seamus's vlog. I hate to disappoint you, Seamus isn't here today, so I'm going to be taking over for him instead. My name is Michelle, I'm a Dutch law student, and Seamus and I actually met each other at summer school, and he asked me to record one of these videos for him. So clearly I said yes, so I will be talking to you about TTIP today. And TTIP is actually something we learned about on our second to last day at the summer school, which was all about the EU as a trade power. Well, I have some personal opinions on TTIP, but for the purposes of this video, I'll try to keep my opinions to myself and remain neutral and just generally try to show both sides of the argument. So to start off with, what is TTIP? Well, TTIP stands for Transatlantic Trade and Investment Partnership, and it's a proposed trade agreement between the United States of America and the European Union. On its official website, the European Commission states the goals of TTIP as being trifold. First is to open up the US to EU firms. The second is to help cut red tape that firms face when exporting overseas. And the third is to set new rules to make it easier and fairer to export, import, and invest overseas. So in short, easier trade and investment between the EU and the US. However, TTIP isn't just concerned with trade and investment, it also involves arbitration. And that is actually an aspect on which Seamus's and mine subgroup was asked to present back at Saarland University. And we were asked to respond to the following statement. Countries are giving up sovereignty through TTIP, true or false? So let's see why that would even be a question regarding TTIP. Well, TTIP in its original version contained articles on something called ISDS, which stands for Investor-State Dispute Settlement. Well, ISDS is basically what it says on the tin, a system of dispute settlement in which an investor from one country, which has invested in another country, can sue that latter country if that country infringes on its rights under international public law. So ISDS was highly controversial for a number of reasons, including the fact that it would involve ad hoc tribunals, which would hold their hearings behind closed doors, so not in public. And the tribunals would not consist of judges in any traditional sense, but instead of 3 attorneys. One attorney would be selected by the country being sued. The other attorney would be selected by the investor who is bringing the claim, and the third attorney would be selected by both parties together. Such a system obviously has its benefits. It's quite efficient. Rulings will probably be expedient, but critics actually argued that it lacked transparency and may not even be in accordance with the rule of law. The European Economic and Social Committee actually pretty quickly took note of how controversial and unpopular ISDS was, and in May 2015 adopted an opinion opposing the inclusion of ISDS in TTIP. And ultimately, not long after, both the European Commission and the European Parliament backed away from ISDS, and EU Trade Commissioner Celia Malmström, I'm sorry if I'm mispronouncing that name, she proposed a new system replacing ISDS with ICS, an investment court system. So this investment court system would involve, in short, replacing those 3 lawyers with publicly appointed judges, and it would clarify the relations between national courts and the investment court system. And it would further make clear which types of cases could actually be brought before these ICS courts. In addition, hearings would now be held in public. And this can certainly be seen as a large improvement in terms of transparency and rule of law. But a principal concern remains for critics of TTIP. Because it's even under ICS, investors can still sue states for infringing on their rights under TTIP. And while they cannot directly ask for regulations to be changed or regulations to be removed, they can ask for sizable penalties. And this can make it harder for governments to implement regulations for legitimate concerns such as health and safety and even human rights. They may not be willing to adopt very stringent regulations on such topics for fear of being sued by investors. So that was a huge concern. Are governments giving up sovereignty to corporations because they're afraid of being sued? At the same time, there are obviously benefits to a system like this. Easier trade without red tape and trade barriers are huge, not just for investors, but also for countries, which are rendered more appealing to said investors by clearer and easy rules. Also, it is a country, so that is one argument to say that this is actually beneficial. Another might be that it is actually the countries themselves which are setting up the rules in TTIP, meaning that ultimately they are the sovereign force. In the end, our group came to the conclusion that while from a rule of law perspective, ICS is definitely an improvement over ISDS, the principal concern of investors being able to sue states actually remains, while there are also certainly benefits in terms of trade for both the investors and the countries. In the end, though, this whole thing may end up being a moot point, because as of June this year, negotiations on TTIP have pretty much been fridged. However, in case it ever becomes unfridged or thawed, so to speak, I hope this video was informative. So thank you so much for watching. Maybe I'll see you another time. And until then, tot ziens.